Welcome to a new episode of SacTown Talks. Today, we have a very special guest talking gaming and specifically card rooms. We have Vincent Oliver. Vincent, how's it going? Thanks for joining the program.
Oh, thanks, Jared. How are you doing today up in Sacramento?
Very well. It's cooling down a bit here, so it's been a nice weekend. But
yeah, it's been unseasonably cool the last few days in Vegas. It actually got down to a chilling 65 degrees one night last week.
Wow, that must be nice.
That's like parka weather this time of year.
Escape from the triple digits. Always good in Vegas.
I know. It's been pretty comfortable actually. I'm sure it will heat up again soon. But I'm actually getting back on the road. I'm looking forward to it. I've been home 3.5 months since the lockdown. I took a couple extra weeks, and I'm excited to get back on the road and start working again.
Nice. So, Vincent, you have a specialty for our listeners, kind of give you a little background about your specialty in gaming, kind of your knowledge in card rooms. Can you kind of give us a little sense of, how you came to be, an expert in California card rooms and kind of, what you're doing in the gaming market right now?
Well, a lot of people, I've always considered myself, I'm an attorney, but I worked for 4 different LA area card rooms for 11 years. And I worked my way through law school working in a card room, so I kind of understand how the operations works. I've always understood how the politics work. And I left the business for 7-8 years in the early 2000s. I came back in 2011, and it hasn't changed all that much. I had to catch up on certain things, but I've always considered myself to be a casino guy with a bar license. I do mostly developmental work. No, I do understand litigation. I can read cases. I can write. I've written stuff in the past, as you're well aware, Jared.
Right.
But my focus basically is on building stuff. I'm not in the business of litigation. I'm not in the business of selling conflict like some of those corporate attorneys do for the card rooms and the tribes. I want to build stuff, and I want everyone to be profitable. That's always been my outlook on life. When I worked in the card rooms, it was from 84 to 95. I had a variety of different positions. My last year in law school, I went to work for a small casino in Bell, which didn't last very long. But I was their compliance director for that time. But I've worked on the floor. I've supervised a lot of high limit action in the past. So again, I have a lot of understanding how it works.
Yeah, California, I guess, has a unique history in gaming. And kind of, what I've always appreciated about these California card rooms is, a lot of them date back to, statehood, the gold rush times.
Before.
Yeah. Can you kind of give us, a sense of the history of gaming in California and kind of, from statehood till, you came into the business in 1984, kind of what was the status of card rooms and, how did they come to be?
Well, I don't know it historically altogether, but we've always had casinos in California, even during the gold rush, particularly. And they were, even though they were not legal, they were tolerated by the state. I don't know the history exactly. I can go from 1936 to the present, and I can go from like 1936 to 1980 pretty quickly. The Prim family, Ernie Prim particularly, he fought the state to have legal poker in the city of Gardena. And he won that case in 1936, even though he'd been operating for about 18 months beforehand. It was 1936 or 1937. And the court, I don't know if it was the appellate court or the Supreme Court, but basically they said draw poker was legal in California. And that sort of initiated this boom, of new card rooms. But it goes back almost 100 years. I can't tell you about regulation or anything like that until 1984. The card rooms were in the penal code until 84, which is the year I entered the business. I started out working the Board of Commerce in 1984, and I left to go work at the Bicycle Hub when they opened later that year. Worked there for 10 years, worked at Hollywood Park for a little bit, worked at this little casino in Bell for a little bit. Then I left. Then I worked as a consultant after graduating from law school and passing the bar. But going back to 1984 is when the Gaming Registration Act was passed by the legislature, and that basically took card rooms out of the penal code, where it's disfavored business, and put it into the business professions code where it could be regulated.
Oh, interesting. Kind of, in this 1980s time period, you have some big seminal cases from the card rooms coming out, around the game of Pai Gow. Kind of, when did games in California start changing from these, draw poker games and poker games to more games like Pai Gow and to some of these, California type games they see today?
Well, I'll start with the Hold'em first. That's pretty simple. 1987, actually 1983, Huntington Park tried spreading Hold'em, limit Hold'em, and they got shut down by county law enforcement, LASD. And back in those days, before there was a gaming commission, the de facto gaming commission was your local county law enforcement. So it was LASD shut the cases down. Huntington Park decided not to fight it. There were some cases going on up north. I think it was the Tibbetts decision, right? Tibbetts v. Vandekamp, if I remember correctly. It's Alma Tibbetts, and I think she was minority. She was an owner at Artichoke Joe's. Do I have the right club? Was it Artichoke? One of the Northern California clubs. I can't remember, it was Artichokes or Oaks. But she won her case, and basically Hold'em was legal. And I don't think if I remember correctly, I don't believe the county appealed. And I remember the decision being, because when the decision was announced, we had heard about it when I was working at the bike. I was working at the bicycle casino for 9.5 years. And it was a lot of excitement. And 3 days later, we started training to be a Hold'em. And we ended up offering Hold'em. That was 1987. The Pai Gow was a little bit different. There was a lot of cardroom expansion in the early 1980s. We had gone from 6 tables of 40 rooms in Gardena, 240 tables for the whole county. Bell passed a measure in 1980. Commerce passed one after that. Bell Gardens passed one after that. I don't remember the exact years, but it was between 1980 and 1983. Commerce opened in 83. Bike opened in 84. And then a couple South Bay area, Compton and Inglewood, passed measures in the 90s. But let's go back to 1984. At the time, the East LA County card rooms opened up expansion, there was a recession in the economy. So you have all this new supply, but not enough demand. So they had to come up with new ways to bring in revenue. I think if I remember correctly, the bike was actually in Chapter 11 briefly to get some heat relief from the creditors. And so Huntington Park started spreading Pai Gow tiles. And I believe Artichoke Joe started spreading Pai Gow tiles as well. Funny is these same two card rooms I got later involved in the whole. That one was involved in the whole discussion before and one after. But they were looking for ways to bring in new revenue and stay afloat because they couldn't make it because the economy wasn't doing so well at that time. And all of a sudden now, instead of 240 tables in LA County, one card room closed after Commerce opened. So you had 200 tables still in Gardena, and you got 60 in Bell, and 100 at Commerce, and 104 later at the bike. So you have all this supply and not enough demand. So they got to find a way, to keep the lights on. And Pai Gow was the answer. And Pai Gow was basically brought in from underground games in Chinatown, and the people who ran those games were the ones working it. And instead of, back in the day, if you were a big game player, you paid 14, 16, maybe $20 an hour in collection. So instead of taking 160 bucks tops in the biggest games every 30 minutes, they got to take up to 80 bucks a hand. The Pai Gow structure back then was 4% commission to an $80 max. So let's say you're betting $5,000 and you have a big Pai Gow hand, you sweep the table. Well, you win all that money, but you only still paid $80 in collections. It was a $4% commission with $80 cap. The county law enforcement tried to shut them down. The card rooms go to court. They win, but they can't take commission anymore because now the California appellate courts ruled that was a percentage game. The percentage game definition in California is different in other jurisdictions, but that's okay for right now for this discussion. What basically happened was the card room started taking collection by the hand, by the seat, instead of on a commission basis. So they were taking every $100 bet, they would take $1. That's how it worked. And everything worked fine at that point. In 1995, they were looking for alternative games. There were actually 2 more games that developed after the Pai Gow tiles. There was a card version of Pai Gow Poker, that was developed by Sam Chirosian. If I remember correctly, he was the casino manager, the general manager at Bell. I couldn't remember which one it was. But he invented this game, never saw the patent on it. It's one of the most popular casino games now in the whole world. And then there was something called Super Pan 9, which was basically Baccarat played with the Pangini deck. Pangini is this rummy form that was very popular in the card rooms up till about 1995, 2000. And as the clientele died off, so did the game. But a Pangini deck is basically a deck of cards with the 7s, 8s, 9s, and 10s removed. So they were basically playing that game, and it's basically a Bach variant. And those were the 3 games they played. Then later on, about 1995, the alternative blackjacks started showing up.
For our listeners at home, can you give us a sense of, I guess, the difference of, between a card room and a Nevada casino or a tribal casino?
Sure. Well, in Nevada, they pretty much offer whatever they want. If they want to add a new game, they go to the state gaming commission. If they want to add a new card, they go to the state gaming commission. The state gaming commission's got a lot of experience, of course, because it is the industry. Las Vegas is a company town. The company is the industry, and the industry is gaming. In California, the card room's a little bit different. Every time the card rooms have tried to add something, they've had to fight law enforcement or go to court to get whatever they wanted, with the exception of the Gaming Registration Act, which in 1984, that was promulgated mostly by George Hardy, who was the owner of the Bicycle Club at the time. And he understood that if the card room business is going to develop in California, you need to eventually be regulated instead of being enforced by the penal code. The card room business just got too large and too sophisticated to be regulated by law enforcement.
Here in the legislature, that we're debating Senate Constitutional Amendment 6 dealing with sports betting, and kind of we're seeing this, this collection of forces of the tribes, the card rooms, and the horses. Can you kind of give a sense of how we got here today of these three interest groups kind of at loggerheads here over an issue?
Well, you got in California, you've got three major gaming stakeholders, as you mentioned: the tribes, the tracks, and the card rooms, and they all pretty much can't stand each other, and they all have competing interests. Racing is still favored in the state legislature, even though the political power is not much as it used to be, because the business is not what it used to be. The tribes are like the 800-pound gorilla. They have enormous political power, probably because, in tribal gaming in California, the gross gaming revenue is around $9 billion a year. That's pretty strong. Think about the jobs they produce. They don't pay state income tax anymore because of the Rincon decision, but they still, produce a lot of communities, and so do card rooms too. So you have these three entities that are all competing with each other. And I find it a little bit surprising that the state of California, instead of taking a corroborative approach with the tribes on SCA 6, they should actually take more ownership of this. It's a $2 billion a year or more platform. And I think if you got these three stakeholders who've never really gotten along with each other, try and figure out how to divide the money, it's going to end in disaster. We've seen it before with online poker. Online poker took 9 years. We never got anywhere with it because a couple of minority tribes didn't like the way it was going to be set up. And then those tribes, unfortunately, had very loud voices in the assembly, and they managed to be able to get the bill shut down year after year after year. It got to the point where the assembly didn't even try anymore. I think that was 2 years ago. But going back to SCA 6, if the state's going to make, and I don't agree with Senator Dodd's been quoted as saying it's going to generate $700 million in revenue. I think that's a little bit optimistic. Let's go with a number that was originally quoted by the experts. Let's say 350 million, but let's go to $500 million. Let's just be generous. I think at that point, instead of asking the stakeholders who've never gotten along with each other how to figure out how to divide the money, I think you need to take ownership of it and tell the stakeholders how the money is going to be divided itself. And there's a lot that's wrong with all of this. And in terms of SCA 6, I don't understand the state's approach. And if a bill doesn't get passed, it's probably on them. But there's a lot of lose in all this. And I'll let you ask your next question.
Yeah, it's kind of interesting. You're kind of saying that the state's kind of backing into this. One of the key points of SCA 6, I guess, is the card room piece, basically clarifying what kind of games card rooms can play and the manner in which they play. Can you kind of give us a background of why this provision is needed and kind of why the card rooms are willing to give up sports betting to, I guess, seek this clarity?
I don't understand why they do exactly. I think they want peace. It's a really complicated question. It's more complicated than you think it is. On the card room side, you've got some really big card room operators that are old school. They've been around 30 years or more, and they think a certain way. Since then, we've had newer, more sophisticated, more business savvy investors. I'm not saying these guys aren't business savvy. It's just that how they think about how to make money in the business doesn't really. I don't think they maximize their value. It's how they came up. They came up in rough and tumble businesses. That's how they made their money, and they think like that. And I can relate because it's kind of like my father. He's self-made and he's done very well for himself over time. But he would say, when I was going, Vince, you should go to law school. It's a license to steal.
Right.
And we don't think that way. You don't think that way. I don't think that way. But a lot of older people who are self-made, who come from immigrant households like my father, I'm Italian American. They think a certain way. And it's unfortunate that attitude still permeates because I think it sets the card industry back. I think the only people in this particular SCA 6, this current iteration, I think everyone did a lose, lose, lose. We'll start with the state. If the state shuts out the card rooms, they're going to sell for 80% of the money. Basically, I can see that at the larger LA card rooms and the larger Bay Area card rooms, I can see significant walk-up action for NFL football, for college football during the fall. And as we all know, football is the bulk of most sports betting revenue. They're going to give that up. They're going to give up the business. They're going to give up the ability to penetrate people who would never go to a tribal casino. And there's quite a few of those people, and people who are not interested in signing up online because they're too old and not technically capable. And I do believe it's 80%, maybe 85%, but it's a significant amount of money the state's giving up to shut out the card rooms. The tribes are the card room side of it probably is $160 million. Now, I arrived at that figure this way. I figured the card rooms will penetrate 40% of the market. The platform is worth $2 billion a year. The card rooms would never, ever be able to take bets on sporting events. Let's be clear about this. The card rooms are basically negotiating for the right to host and charge rent or do a license arrangement with a service provider sportsbook. That's what's at stake here. They can never take their own action ever. It's not like the tracks who could invest in this to take a piece. It's not like the tribes who could take a piece. And certain tribes are wealthy enough where they could probably, and a couple tribes actually have sophisticated enough management. Not saying that there are bad GMs, but there are a couple guys who have significant sportsbook operation experience that could actually run their own sportsbook, and the bank was large enough where they could withstand the fluctuations quite comfortably. So the state's giving up money. The card rooms are basically giving the tribes a $160 million gift to leave them alone. And when I say leave them alone, they're just tired of further litigation. They don't want to fight this anymore. I don't believe this is unanimous within the card room side. I'm sure there are card room operators that want to have sports betting, but you have some really large operators and they're old school investors, and they just want to be left alone. And I can understand that point of view, even though it's not correct. I still certainly understand it. And the tribes who have, we're going to have to talk about this table game issue in a second. And the tribes are refusing this $160 million gift, probably for all the wrong reasons. But let's go back to you and see where you want to develop this.
Yeah, during SCA 6, there was testimony from a lot of tribal groups, and there wasn't much talk about sports betting. There was mostly talk about this, card room piece, about how these tribal governments feel that these card rooms are taking business from them, or I guess playing illegal games. Can you kind of give us a sense of where these complaints are coming from the tribes, and kind of what's the basis of them?
Well, I think we need to analyze what's happened. Like I said, I left you at 1995, a little bit earlier in the discussion. In 1995, alternative blackjack games came. They started introducing card rooms, and the so-called carnival games came a couple years after that. So they've actually offered the games that the tribes are complaining about for 25 years now. We're in 2020, right?
Right.
The first alternative blackjack game was 21st Century Blackjack. It was developed by Mohammed Mastasari. 21st Century Gaming. He's a great guy. He's a former Asian Games manager at Commerce. He's still very close to Commerce. I think he works as a consultant now or as an advisor with them, but he's been with them ever since day one, which is 37 years. That's a long time. They introduced that game in 1995 or 1996. And they've had these games for a while now. The reason, and at about that time, there's a similar discussion. As the viewer is going to see, this is a multi-layered discussion. Around 1980, when the tribes won the Cabazon decision in 1987, it led to the formation of IGRA. And in the early days of tribal gaming in California, they offered class 2 or player dealer or peer-to-peer blackjack. Basically what happened was this: everyone would get one, you could bank the game, they'd take turns banking the blackjack, they would get one shoe to play, then the shoe would move to the next position. In California, we have a similar structure, except they don't get the whole shoe, they just get 2 deals. And then the player dealer button moves. But actually, these games started with tribal gaming in the late 1980s, early 1990s. And the corporations started showing up when those opportunities evaporated after tribes got wealthy enough to have something called player pool, which is basically, it's a fiction. They just host the game, but they take all the profits and return them to the player. They collect a service fee, which is usually 15-20%, and then they return the rest of the money, and they return the rest of the money in the form of promotions. So these games have been around for a long time. The tribe's issue with the card rooms is that they feel the games are illegal because only one person gets to take the bank. That's not quite true. Everyone gets opportunity to take the player dealer position in a California card room. It's just that most refuse because, even though they only have to risk 10, $20, they just rather have the player dealer do. They don't want to disrupt the flow of the game. They're only getting about $20 a hand or $10, whatever the table minimum is. That's what's going on there. And the tribes feel they have an exclusive on these games in California. It's just simply not true. They rely on precatory language in the preamble to the compact, not the compact itself, which says they give them the exclusive opportunity. Their tribal gaming attorneys and lobbyists have told them they have a monopoly. Yes, they have a monopoly, but it's one that's based on fact and not based on law. And where I'm going with this is this. Yes, there's a big difference legally between having the only game in town and having the people give you, actually grant you a monopoly, because when you grant that monopoly, you pay for it. You're paying for that right. And the other larger issue is this. We don't grant a monopoly to a class, we grant a monopoly to an individual, right?
Right.
Pretty much. And so that's their argument. Unfortunately for them, they've sued in court, both in state court and federal court, and they've been bounced out of court. Both cases are on appeal, but the judge in the federal case up in Sacramento, John Mendez, was pretty clear about it. It was a very short decision. He said the only people who can do this, give you the monopoly, are the people of the state of California. The sections they rely on, Article 4, Section 19 of the California Constitution, legislature shall prohibit not authorize casinos of the type of Nevada and New Jersey. They rely on that for their monopoly, so-called monopoly, but the court said the legislature can't give you a monopoly, it's the voters. So they're trying to bypass this process. But however, even though the card rooms are 2-0 against the tribes in this, and I believe on appeal, it'll be a very, very easy 3-0 decision for the Ninth Circuit. It's a really basic matter of law. They just don't want the hassle anymore. And I can understand why, but again, there's something kind of wrong with that picture. When you're 2-0 in court against the tribes, and you still want to give them $160 million a year to leave them alone on table games issue, something's wrong.
Right. It's kind of interesting, this rotation issue, this player dealer issues, we're talking about. It's something that you're very central on, for your case, Vincent Oliver versus the County of Los Angeles. Can you kind of give us a sense of why that case was wrong and kind of what your thoughts were, I guess, heading into that case, and what you believe the law was at that time before that case came out?
Well, the penal code, the reason we had the blackjack alternative games is because the penal code bans specifically the game of 21. So in California, penal statutes are to be strictly construed. So you take those two concepts of law and you just invent games that are like blackjack, except the target's 22. County law enforcement in Los Angeles was on the record as saying they had an issue with the bust part of blackjack. So we fixed the bust part of blackjack. Different games had different ways of resolving it. Our method of resolving it was, let's say you go over, let's say you have 25. The dealer busts on 25, that hand's now a push. So the bust rule is no longer really in effect. What happened to me was this court decided this novel concept of the law, even though my game was not 21, it had the potential to be a banking game. And we're not certain what that means in the penal law. Penal law, if that's true, then these pillows on this couch next to me have the potential to suffocate people, so they should be outlawed, right? It's the same mentality. And it's an unfortunate decision. It's an outlier. It's something that should be restricted. Apparently, Commerce Casino agrees, because Commerce Casino went and tried to have the decision published a couple years later, and they were rebuffed by the appellate court. So we have a lot that's wrong with that law, but it's really an outlier. And besides, the tribe, the legislature enacted Penal Code 33011, I think it was 2000, 2001, and 33011 basically addressed a situation where, the court said it was potentially a banking game because everyone passed the bank to the guy with the big money, and that for some reason became a banking game. Even though every single individual player had opportunity to be the player dealer, and even though our rule sheet was what the state asked, was what the state DOJ asked for. So not only was the decision wrong, they said a couple things in the decision which simply were not true. It's really unfortunate, but that's life. I moved on from it a long time ago. But the tribe seemed to rely on this, and it's more the tribal gaming attorneys and the lobbyists. They see this little piece they can work. They see this language in a in a decision, they can work with it and they can go sell conflict to the tribes. And, I need to stress this to the viewer. The tribe, you say 2008. Now, I wasn't in the business in 2008. The first legal document I saw was in the fall of 2012, which was a full 17 years after these games started. It was a full 10 years after prop services were regulated in California. Why did it take them so long to argue, to fight this? I have a theory why, but go back to, you were around 2008. What started happening then?
Well, I guess we had the economic crisis in 2008. But I guess to go a little further back, you mentioned Penal Code 33011, coming in around 2000, 2001. Kind of at that time, why was Penal Code 33011 necessary?
Well, it was to overrule the decision in my case, essentially, even though the guy who wrote the bill wouldn't say so publicly. The cardrooms promulgated it. There was an issue with some of the language, and they thought there would be a problem down the road, and they were obviously correct. And they got 33011 enacted, and that was actually Daryl Myers' responsibility. Daryl Myers was managing partner of Core Capital Management. Before Core Capital Management, Daryl Myers won, and his partners, who were all professional gamblers, they won a bunch of money banking the Indian blackjack in California, New Mexico, Texas, and I think Oklahoma too. It was one other state. It was those three for sure, and Arizona or Oklahoma. So they're all throughout the Southwest. And Texas, remember, had tribal casinos for a little bit, for a couple of years in the early 1990s, before then Governor George W. Bush outlawed them, and they won a decision in court. And that's another issue. That's a separate discussion altogether. But anyway, the tribes have known about this for a long time, and it took them 2008 to 2012, take your pick. It took them a long time to litigate over this issue, and it's kind of curious. If you go back to the history of tribal gaming in California, what do you think happened after Prop 1A was passed in 2000? They already were running casinos. They already were running slot machines. They just had to get it legal. After Prop 1A passed in 2000, well, folks that were getting distribution checks from these big tribal casinos started families. And when you start families in 2000, 2001, because it's your kid, it's going to get a check when they turn 18. So if you had 2001 to 18, you get 2019, right? So that's why this discussion has been ramped up a lot in the last year and a half, because these kids are now 18 years old and they're getting a check from the tribal government, and the check depends on what percentage blood they are. And the tribes saw this problem coming. First, they tried disenrolling some of the members. They tried disenrolling people that were either questionably part of the tribe or didn't have enough blood of the tribe. They disenrolled those people. But as the tribal rolls increase, some of these checks are 10, 15, even as high as $40,000 a month. You're used to living that kind of money. You don't want to take a pay cut. That's certainly understandable too. So they got to find another way to raise revenue to pay for this. It's been my belief the entire time. It's not so much the issue. It's not so much because they want to dominate the gambling business in California. It's because they need the money. Yeah. And that's what it's really about. And I think the evidence, the timeline, if you go back at 3 or 4 things that have happened over the last 20 years, starting with the passage of Prop 1A, which basically led to all these tribal casinos in California, that's why we have the situation we have today. And the tribes can't blame other tribes. That's a bad look in public, even though I think it's a pretty compelling argument that the biggest casino that hurts tribal gaming revenue in the Sacramento area is the Class 2 casino at Lytton, which was basically invented in a last minute congressional session by a lame duck congressman in a lame duck Congress. You have this tribe. Their native grounds are in Healdsburg, which is 65 miles away from Casino San Pablo, and they all of a sudden they got to move their tribe to the Casino San Pablo site so they could operate this Class 2 casino. It's kind of curious. That business probably impacts tribal gaming more in Sacramento than any of the cardrooms. And that includes a niche place like Casino 580, which sometimes has really big table action. The six cardrooms in the Bay Area that are in port, 580, Bay 101, Matrix, Oaks, California Grand, Artichoke Joe's, if they had to go back to, the old way of doing business with the table games, the 3 traditional games, the Pai Gow Poker, the Pan 9, the Pai Gow Taos Tomorrow, they're not going to lose that much business, and the tribe's not going to capture any of that business. Most cardroom customers are customers of convenience, and I think a lot of people don't really understand that. You have a lot of people, for example, in Los Angeles, there's no cardroom that can offer what a tribal gaming facility can offer. But you have people they just want the action. They don't care if they can stay. If someone lives in Alhambra, they'll drive 15 minutes to Commerce instead of 45 to San Manuel, even though San Manuel can offer them better pricing on the games they play. They'll comp them a lot easier. They'll give them whatever they want if they play enough. And if they need a room, they can put them up for free. And they can offer all those things, and Commerce really can't. But they still want to save the half-hour drive. They just want to be in action. They just want to go to the closest place where they can be in action. And the tribes understand this, I believe. And, again, it goes back to them needing the money. But again, like I said, these complaints to the state about their monopoly and these illegal games, look, why didn't they complain when these games were introduced? Obviously, they couldn't in 1995 because they weren't really up and running, but certainly by the time 2002 came around and the prop services were regulated, they certainly had, a year or 2 years to look at it, not 6 or 10, depending on whose timeline you're looking at.
An interesting issue the tribes have brought up in their arguments and in their letters is this famous Lytle letter. Can you explain what the Lytle letter is and kind of what it means?
Oh, yeah.
Place in history?
The Lytle letter is pretty entertaining. The Lytle letter basically was a codification by Robert Lytle, who was the bureau chief at the time. This was when I was not in the business in 2007. He was the bureau chief, and he was also assistant attorney general. He basically gave what I believe is the correct interpretation of 330.11, but it actually came from a state law enforcement official. The problem with that letter is that even though it's an opinion letter, it's not an official opinion letter. Government, was it government code 12.519, 12.915, something like that? You're familiar with what I'm talking about, right, Jared?
Yeah.
In California government code, if you want an opinion, there's only a certain number of people that can ask for an opinion letter. That's a legislature, it's a county DA, it's an assistant DA, maybe some other law enforcement officials, but it's a literally limited number. And they're all government and senior government officials for the most part. And the opinion letter was asked by a cardroom owner. So it's really not an official opinion letter. And then we fast forward to 2016, 2017, when then Attorney General Kamala Harris, quote, suspends this letter. That's even more entertaining because this is a letter that really should have no legal effect in the first place. It may have probative value in a civil case between the tribes and the cardrooms, but that's for the judge to decide. And even if we're an official opinion letter from the government, the judge can still disagree with it. As we all know in practice, even though if it were official opinion letter, it'd have a lot more probative value than this informal letter, which isn't even an official opinion. The judge can either agree with the letter or not agree. That's what it usually comes down to. That's how it works in practice. I mean, even though the AG letter had, an official AG letter would have a lot more weight than Lytle's letter. But this whole thing was just a bunch of kabuki, and I'm just surprised. I mean, the tribes have a right to be mad at Lytle for writing it. I understand that. There's a certain ethical question that comes with writing it, but it doesn't change the fact what he wrote was probably correct. And it's for a judge to decide how much value that should have.
Interesting. Just kind of, circling back to, I guess, sports betting and SCA 6. Earlier in the year, the tribes put out their own initiative, and we're gathering signatures on that. It doesn't look like that will be able to qualify for this ballot. But I guess what are the key differences between SCA 6 and the tribal initiative, and why were the tribes so supportive of their initiative and not supportive of SCA 6?
Well, the SCA 6 issue is because they want to really eliminate the table games in the cardrooms in California, and that's probably not happening. With their initiative, the reason they want to go to the state is because they want to have mobile. Don't believe what you see, what you've read previously. You've seen from certain senior tribal gaming officials, whether they're working with NIGA, NIGC, or their own tribe, saying we don't want mobile. That's not true. They understand the numbers, believe me. Everyone knows that mobile will bring in 5 times the revenue as walk-up only. Everyone understands that. So let's get that out of the way first. The problem they have is with their own initiative. First, they have 2 problems. One, because of the coronavirus pandemic, they actually have to now go sue the state and get more time. I don't know how the state's going to decide on that, or how the court's going to decide on that. Your guess is as good as mine. But let's say if they can't, they get enough ballots, they get enough signatures in time, which they probably can. There are a couple of provisions in that are, it's sort of a compromise that they want to keep themselves. NIGC issued a bulletin back in January, which basically told the tribes how they could do sports betting on the reservation, and they can do mobile as long as the mobile doesn't leave, as long as the geolocation does not leave the reservation. So if I'm at San Manuel, I can make a bet from the Arco station at Highland and Victoria, but I can't make one from across the street at Food for Less. That's where the reservation is north of Highland Road. That's what we're talking about. You can make a sports bet on your phone in the casino, but you can't make one from your home and say you live in Rancho Cucamonga 20 minutes away. They can only really have walk-up only and mobile within geolocated to reservation grounds only. That's one issue they have. The second issue is they have this, quote, private attorney general provision, which is basically putting the cardrooms on double secret probation for those people who remember Animal House. And that's kind of problematical for the cardrooms too. It basically allows people, if they see what they think is a gaming violation, they complain to the attorney general. If the attorney general doesn't give them the relief they want, then they go to court and sue. This is basically a private attorney general provision disguised as a SLAPP provision. And I'm kind of curious if this initiative ever passes and these are private attorney general actions against the cardroom start popping up, whether a cardroom could actually interpose a SLAPP. If you don't know what SLAPP is, it's basically a First Amendment defense. Basically, they're suing you to prevent your right of free speech. And we've seen some expansions in the California Code of Civil Procedure or the California Civil Code, which allow for expansion. So I don't know how it would apply in a commercial setting, but certainly they can interpose a defense and a judge might agree with them. So that's problematical too. There's a lot that the tribes don't like about this, but they're more upset about this, table games initiative, which has been sold to them by their lobbyists and their corporate attorneys. And remember, like I said at the very beginning, lobbyists and corporate attorneys are in the business of selling conflict. They charge a lot of money for their services, and I really don't believe they're doing the tribes a service doing this.
If SCA 6, doesn't move forward, where does that leave the card rooms, I guess, in seeking clarity for the games they play?
Well, let's knock one out of the way first. Assuming SCA 6 does not get through the legislature, and depending on who you believe, I talked to one senior card room executive a few days ago about this, and he says he's not holding his breath, and that's probably a good viewpoint to take. I have, one leading gaming industry writer say it's 96% it won't pass. He's got 4% it will pass. That's just getting it to the electorate. I think the electorate would pass a bill if one would pass an initiative, if one were presented in front of them. But there's a couple other things that may happen. You had Dan Wallach on last week. I haven't had a chance to look at his interview, but Dan goes from jurisdiction to jurisdiction, trying to find ways to bypass the electorate when the electorate is the party tasked with approving expansion of gambling in their home states. He made some really interesting arguments that at the informational hearing, was it back in February? Right. January, February? Yep. Yeah. Basically, that because going back to Article 4, Section 19 of the California Constitution, legislature shall not authorize and shall prohibit casinos of the type of New Jersey, yada, yada, yada. Where does sports betting fit into a traditional casino structure? One argument you can make, and he's got a bunch of different arguments, and they're all historical. And, I don't know if this will be presented again, but one argument you can make just basically, well, if it's Nevada, New Jersey, the reason we're here is because New Jersey couldn't have sports betting. They actually had to go to court. They had the Supremes take their case and reverse, a circuit court decision saying they couldn't have sports betting. That's where we're at with this. So if New Jersey couldn't have sports betting, where does the California Constitution provision we just discussed fall into play in this? It's kind of problematical, isn't it?
Right.
So you may see something like that. The legislature, they could just do a legislative take. They just take an existing gaming bill and rewrite it to include sports betting and basically bypass the electorate. Now that, of course, would meet with tons of litigation. But again, the legislature at some point should take ownership of this. We go back to what I said originally. You're looking at something. You have a budget shortfall of $54 billion. And you have other issues. You obviously have problems balancing the budget because your pension plans are too generous, and I believe CalPERS will bankrupt the state of California in 20 years unless there's significant pension reform. Let me give you an example of that. California is 45th in education on K-12 students, K-12 per pupil. They are 45th in the country in spending per pupil, kindergarten to 12th grade. They are, for every dollar they spend on educating somebody, they spend $1.70 locking someone up. That's the highest ratio in the United States. So when you have the fifth largest economy in the world, when you have a tax base like the one you have, and you produce numbers like that, there's obviously a problem. The obvious problem, and the obvious answer is the pensions. The pension debt in California is the highest in the U.S. in dollars by about 20 light years. And per capita, they're second only to Alaska. Alaska's got the oil business. They're fine. They'll have no problem balancing the budget. But California, the pension funds eat up such a significant part of the budget every year. When you see budget cuts, that's why you see California being 45th. And of course, the tribes have the same problem because they have all these newly enrolled tribal members who turned 18, 19 years old, and they got to find a way to pay them whatever it is they get a year. So you have a lot of lose in this.
Interesting. Kind of, looking across the nation, I guess there's a lot of models, a lot of interest groups, in different states seeking to legalize sports wagering. In your opinion, which state has the best model, and which model should California emulate?
Nevada, they've been doing it the longest. That's pretty easy. I mean, even we see issues in New Jersey. New Jersey is probably the leading gaming jurisdiction in the world because they have so much experience with online gaming, which Nevada doesn't. New Jersey actually has been trying to set itself up the last 10, 12 years to be the go-to place in the world for online gaming, because they have a robust online gaming market in New Jersey. But it never hurts to go in Nevada. They're the world leader. They always will be. They will be the world leader 100 years from now, probably, in gaming. You go with them. And another issue that we probably should talk about in this table game fight is one of the issues the tribes are correct on. And don't misunderstand me with this. I love tribal gaming. I have a lot of friends in tribal gaming, mostly on the casino side, but some on the tribal side as well. A lot of love for them, a lot of respect for what they built, a ton of respect for what they built. But I think they're fighting the wrong fight here. But going back to what I was saying before, if we have the world's fifth largest economy in California, why can't we regulate our gaming business like the world's fifth largest economy? It's not like the Department of Real Estate. It's not like agriculture. It's a specialized business that needs significant regulation. And unfortunately, I think the state needs to take gaming more seriously in California. I think they'd be very well advised, the next bureau chief, hire him from Nevada and New Jersey, and let him go to work. What he feels is necessary, because we've seen regulatory fails in California in the past. We see card rooms getting to write a check out for their bad behavior where they really shouldn't have licenses, and that's a problem. And if we're going to advance as a gaming jurisdiction, we need to actually have regulation that represents that. And hopefully, the legislature will see this and hear this and maybe take my advice on it in the future.
I guess, you pointed Nevada as a good model. Can you kind of explain what makes Nevada's model so great, and kind of, how could we apply that here to California?
Well, they've been doing it legally the second time for about 90 years. They have significant experience, and they've been taking bets on sports for God knows how long, and they have a lot of experienced people, both more in the retail than the online. But again, I mean, they understand online too. I mean, there's a difference between how a retail walk-up book works and an online book works. But they have the experience, and I think you got to go with that experience and acumen. Basically, if you hire someone in gaming, and if you have a big enough gaming company, chances are that person, that senior executive, will have been licensed in Nevada, New Jersey previously.
One interesting thing that I guess, we've tried to emulate here in California, we've been looking at countries such as United Kingdom, Spain, Italy, seeing the revenue they're getting from sports betting. Are there such, barriers to entry and interest groups in these countries? Or, kind of like Nevada, is there, lots of competition? Kind of how would California's, I guess, limited gaming markets compare to, other states or other countries in terms of, the ability to generate revenue?
Well, the one jurisdiction that California is most closely associated by analysts is the UK. The demographics are close enough. The population is close enough. I think the UK's got a little more population. I think the UK is 50 million people as opposed to California, which is 40. The person you probably want to ask would be someone like my brother. He's a consultant. He's a former e-gaming regulator. He was deputy director of licensing for Alderney. He knows the European market, the online. He's licensed a ton of online sports, but he'd probably be the better guy to ask that question.
But I guess, my real question is in Nevada, you could, I assume, could start a sports book tomorrow if you wanted to, if you had the financing. But here in California, I guess they're only talking about existing entities or tribal casinos having that right. And I guess, that lack of competition or that lack of ability to enter the market, I guess, how do you see that harming the state's ability to raise revenue?
I don't think it will because I mean, I talked to a couple other gaming attorneys who are much closer to the sportsbook space. They do it full time, and they're telling me basically how it works and how it's probably going to work in California. It's going to be FanDuel, William Hill, another maybe Bet365, and the smaller companies are going to compete for 10, 15% of what's left. I think at the end of the day, whoever signs up, I mean, William Hill. I'm sorry, I'm losing my train of thought here. FanDuel, William Hill probably will dominate most of the market. Bet365 will do a significant part if they want to enter the state of California. And the rest of it will be the smaller companies. I mean, there are a bunch of sports betting companies out there, but I think these three companies may dominate the market. Unless somebody like MGM comes in or Caesars comes in. Now, Caesars, of course, has a relationship with the Rincon band. They may get a piece of that pie. That may impact it. But at the end of the day, you're probably going to see, 3 or 4 really important operators. You might see 4 or 5 more minor operators. But the people that come into this, and remember, if the card rooms were allowed to have sports betting, card rooms would not be able to take a piece of the action. They'd have to charge rent or a licensing fee to make their money. So they can't really have an interest in it. They would never have an interest in the outcome of it anyway. So they're going to sign up. They're going to sign up with someone like FanDuel or William Hill, someone that's going to maximize their income.
You alluded to, I guess, internet poker taking so long, and kind of one of the big issues in internet poker is interest groups started partnering with different entities, and one of the big ones was Poker Stars, who dominated, I guess, a big piece of the market. And it was kind of felt that if you didn't partner with the biggest company, that you weren't really going to make any revenue in this. Do you see that being an issue here? That this interest groups are going to look for partnerships, and if you're not partnered with one of the 3 or 4 companies you mentioned, you're going to be on the outside looking in?
Well, the online poker deal was a little bit different because you had one really dominant operator. That by the way, Stars is not as dominant as it used to be. They still dominate the business, but not to the extent. WSOP is a strong brand, and you have a bunch of other brands that have developed over the last 4 or 5 years that have started making an impact on revenue and market share in the online poker industry. Sports betting, I think the licensing is going to be a little bit different. I think basically it's going to be a service provider and a stakeholder, and I think the service provider can sign up as many stakeholders as they want. So the issues are somewhat different than it was in online poker. I think with online poker, the way I understood it was that some one tribe or maybe a coalition or 2 or 3 tribes or a coalition of a couple tribes would get stars, and Caesars obviously. Caesars today operate Rincon with the WSOP. So you left a bunch of other tribes and a bunch of other card room operators fighting over maybe 5% of the market. So I can understand some of the dynamics of the online poker fight, but also online poker would not generate nearly as much tax revenue as sports betting. And that's probably why the legislature acted the way it acted in terms of letting the stakeholders decide the conditions of contest. When you're looking at $10 million of revenue, that's one thing. When you're looking at $350 million to $500 million of revenue, that's another altogether.
So, I guess it comes to this, Vincent, let's say, you get to draft the initiative. It's your initiative for sports betting here in California. How would you draft it?
Okay, well, that's interesting. I was fine with the original. I think Adam Gray had ACA 18 a couple years ago. ACA 16, ACA 18, mm-hmm. ACA 16. It was I think 16 versus 18. I can't remember which one was first, but basically, it's a pretty boilerplate template type situation. You have a couple different categories of licensees. You have the service provider, you have the stakeholder, and that's fine. The issue with the stakeholder with the card rooms is that some of the card rooms have had issues in the past with the state. They've had issues with the federal government in terms of AML violations. I would have a bad actor clause to cover that. If you've been spanked by the state of California or by FinCEN and Department of Treasury the last 10 years, you have to be in the penalty box for a while before you can offer sports betting in your card room. That's how I would have done it. I'd let the tribes get involved. My deal would probably just have the tracks in the card rooms. If the tribes would submit to regulation, I would include them also. You want to secure. The problem with the tribes is because they won the Rincon decision, you have to pay state income tax. And one of the issues I see with SCA 6 is, even though this money goes into something called a sports wagering fund, sports wagering gambling fund, something like that, there's a lot of general fund stuff in that fund. And I can see the tribes going back to court 2-3 years after this, if they pass this and the electorate actually, gets to vote on it, which I doubt is going to happen. But let's say best case scenario for everybody, the tribes change their mind, the legislature says, let's have the electorate decide it, and the electorate passes it. I still think they're going to go to court 2-3 years later to sue to get out because they need the money. It's not because they don't want to pay the state the money, they don't want to be a bad neighbor, they don't want to dominate the cardroom industries. That they have all these tribal members, and they, again, they get some of these checks go to $500,000 a year, and they want to keep that lifestyle. And that's certainly understandable. It's not necessarily correct, not necessarily right, but that's what we're dealing with.
Interesting. One key piece you kind of left out is you didn't have a way to solve the card rooms issue with their games. Kind of without a constitutional amendment, how did the card rooms, solve their issues with, allegedly the attorney general looking to change regulations on them, threatening to withdraw games? Where do the card rooms go from here without some sort of, global bargain with all the interest groups?
Well, my take is something like this. I can't predict what the attorney general is going to do. Also remember the current attorney general is a former U.S. congressman, and he's, Xavier Becerra is a good guy. He's an ambitious guy. I don't know how long he's going to be attorney general. I think, we had a conversation about this week. You raised that point. Assuming that Trump gets defeated in November, and it's looking like that way right now, assuming with the Biden administration, I'm sure there's a place in the Biden administration for someone like Xavier Becerra. There certainly is going to be one for Kamala Harris. I don't see Kamala Harris being a U.S. senator that much longer. There's been stories that say she's not comfortable being a senator. She'd rather be in the executive branch. And I can see Biden offering her, if she's not going to get the VP spot, she's going to get the AG spot almost for sure. That's going to create a Senate opening. And I don't think there's ever been a Latino ever be a U.S. senator. And in a state with Latino population 30%, that's pretty significant. So I can see Becerra being a leading candidate to be the next U.S. senator, assuming Kamala Harris, takes a job with the Biden administration, either as VP or the Attorney General. So, and if that doesn't work out, then 2028 comes along, he may run for governor. So he's got a lot of options open, but I don't see him being Attorney General for that much longer. And with a different Attorney General, you might get a different point of view on things.
So I that could be a long time though. What should the card rooms do, here in the next, 6 months to a year? Been talks about, forced rotations, collection fees, mandated collection fees. Should the card rooms just hold on and fight for the status quo, or should they seek some sort of resolution?
Well, all I know is this. Once you've been entrenched for as long as the card rooms have these games, it's extremely difficult to remove these games. Look what's going on in Florida. The Seminoles are pretty much the gaming industry. They're probably the largest tribal gaming company in the world. They operate a bunch of casinos in Florida. They make lots of money every year. They're now expanding. They operate casinos now throughout the U.S. Tribal casinos. They operate the Hard Rock in Atlantic City. Used to be the Trump Taj Mahal. They have tried to eliminate internet sweepstakes cafes, and it took them 9-10 years to do so. And these are penny ante businesses. They operate in rural areas. And basically, the deal is this: you buy $20 of internet time, you enter a lottery where you try to win a couple $1,000. That's how it works. And they've tried to shut these places down forever, and they've got most of them. It took them 10, 11 years. They finally got most of them, eliminated. But there's no gaming commission in Florida per se. It's the local law enforcement, just like it is in California. And some of these local law enforcement let these places operate. There's a few of them left, but it's not like it used to be. If it took them 11 years to reduce the footprint of internet sweepstakes cafes, they've been trying. In 2014, the Department of Pari-Mutuel Wagering. Let me go back to Florida. Florida is very similar to California, except the card room industry. You have to have a racing license to own a card room in Florida. So basically, the card rooms and the tracks are merged into one. They're integrated into one. So basically, your stakeholders are the Racinos and the Seminole Tribe of Florida. They've been trying to get rid of Florida in 2014. The Department of Pari-Mutuel Wagering, they enacted a new rule. This is a rule, not a statute or a regulation, but a rule that basically was cut and pasted Penal Code 33011, which they call them designated player games in California. Florida, but it's the same thing as player, dealer, peer-to-peer gaming as we know it in California. It's the same structure. I'm pretty much identical. And the Seminoles have been fighting to eliminate these games ever since they were introduced in 2014. That's been going on 6 years. They've made zero headway. And I predict they will continue to make zero headway. They won a court case a couple of years ago, which basically let them off the hook for paying. They were suing the state of Florida for violation of compact, and part of that deal was on the table games for violating, they said the state of Florida violated their compact by letting the casinos have these games. Well, they won in court, which all that meant was they didn't have to pay them revenue sharing anymore. Let me give you a dirty little secret about it. The state of Florida is probably okay with that. There was a Spectrum Gaming report. The Florida legislature contracted them in 2013. There was this monolithic, 800-page report. And they gave a bunch of scenarios. But I just fast forwarded to the one scenario where, according to Spectrum, if the state of Florida told the Seminoles to have a nice life, keep all the tax money, we don't need you anymore, and they gave the racinos whatever they wanted, tax revenue would not only been increased, but it would have been increased by the multiple of around 2.5 to 2.7 times. And believe me, the legislature is very much aware of that. So they're going to try and shut this down every year, for the next 15, 20 years. They're not going to go anywhere with it. And I think something similar is going to happen in California because it's been so entrenched for so long. But as long as you have that fear, I can understand the cardinal's point of view too. But again, they've been doing this a long time. I just don't see these games being uprooted anytime soon.
Interesting. Kind of, I guess at the beginning of the show, you were describing your history. You said you like to build things. You like to kind of work on, I guess, making things better, making a future play. In your opinion, what is the future of California card rooms, and what is this business going to look like in 10 years?
Well, it depends what the regulation looks like. If the state really needs better regulation, better law enforcement. Look, the Attorney General announced he was, and again, I don't mean this is not intended to be critical of the Attorney General. I need to stress that from the beginning. The Attorney General closed down 3 card rooms. They were all little card rooms. And he let the big card room, who was the biggest spender, off by writing a check. And it's a big card room in LA County. They were misbehaving really, really badly on a scale much, much worse than those 3 card rooms. Of those 3 card rooms, I can't speak for the 3-table one, but the 6-table run, the one that was in Paso Robles, has been on the block for at least 2 years that I know of, because I know people actually tried to buy it. And the one in Sacramento was probably going out of business anyway. They were running out of money. They were basically insolvent.
Right.
So while this stuff looks good on paper, if you analyze it, the Attorney General, it was a very cheap political cost for him to do this. And in terms of what happened down south with Hawaiian Gardens, it's kind of unfortunate. And again, I go back to what I said before. You have a lot of people in California who have licenses that couldn't get licensed anywhere else. And that's kind of problematical too. And the state should really look into that and why that is, but they won't. So my solution is this: let's not focus on what happened in the past. Let's build a better future, and let's get a regulatory enforcement arm that befits the world's 5th largest economy. Hire the best in the business and figure out what they need to do. Because the issue isn't the state, the issue isn't the structure, the issue isn't the people. The people who work in gaming in California, whether they're on the commission or the bureau, they're good people, they're intelligent people. It's just a training issue. They're not trained at all. For the most part, they're not really trained properly. And you got to give these people the best opportunity to succeed. And the way things are set up right now in the state, that's not happening. That's really unfortunate, because I think we can get to a win-win with everybody, and we can put the card rooms on notice. I think the most important thing in all this whole process is the state of California. We look how it regulates and enforces, and bring in a consultant to make suggestions. Bring in a bureau chief with gaming enforcement experience, someone like DG in New Jersey or Gaming Enforcement Division in Nevada, someone like that. And let's have gaming professionals operate this business going forward. And let's train the people we have so they can do their jobs the right way.
Interesting. Well, thank you so much for joining us today, Vincent. If people want to get a hold of you or follow you on social media, what's the best way to get a hold of you?
Well, I'm on Twitter, tangerinelaw.com, and if anyone's interested, you can write me at info@tangerinelaw.com. I'm at Tangerine Law on Twitter. Excuse me, at tangerinelaw.com. But info@tangerinelaw.com, you can write me at. And I'm not really talking about gaming these days. We got a few other things going on, in our society that need to be changed as well. We got a pandemic that we need to fix. and we have social and racial justice issues that we need to fix too. And I've been tweeting mostly about that these days. But
yeah, definitely.
Those things are really important. Hey, Jared, thanks for having me. Appreciate you greatly, and we'll see you next time.
All right. Thanks, Vincent. We'll talk to you later. Thanks.
Okay, thank you. Have a good day.
Some are called dreamers.